Good morning and welcome to our webinar about COVID BI claims, which continue to feature in the courts, which is why we've called it Rumbling On. I'm Ben Hardiman. I am a partner in our insurance dispute service line, and one of the areas I specialise in is claims against brokers. I'm delighted to be joined today by Shaira Begum, who is an associate, and she has a developing interest in claims involving insurance brokers. So just to quickly cover off housekeeping, I'm sure everyone on the call will have been on one of these before, but we are recording the session. It'll be available to view later if you want to pass on to any colleagues. And of course, if you have any questions, please do pop them into the Q&A box, and we'll try to address as many as we can at the end of the seminar, or alternatively, we will respond to you and follow up in writing, as long as you haven't kept it anonymous. So today we're going to focus on an area which has been on the radar really since spring 2020. Remember those terrible days and the impact of COVID on business interruption cover. Now, around 6 weeks ago, the High Court handed down 3 further judgments in 3 separate cases, brought by some pretty large policyholders operating in the food and entertainment sectors. So Stonegate, which is the largest pub company in the UK, they sell enough beer in a year to fill 32 Olympic-sized swimming pools. We've got Greggs, who I'm sure everyone will know. Interesting fact for them, they sell more sausage rolls than McDonald's sells Big Macs in a year. I might contribute to some of those myself. And while Various Eateries is slightly smaller, it's still a significant player in the restaurant and hotel space. It's got brands such as Copper Club and Tavolino. Now, the same judge heard and decided all 3 claims. They weren't joined together as such, but they were handed down. The judgments were handed down at the same time. He is also the judge who heard the FCA test case at the first instance in the High Court. And of course, his judgment, or parts of it, were successfully appealed to the Supreme Court. What we're going to do today is to take you through the key findings in the judgments, and we'll provide some thoughts on the impact and implications of these decisions for the brokers on the call. Firstly, we just thought a quick canter through the rumbling ons as such to show what we've seen since the Supreme Court's decision was handed down in January 21. We had Rockcliffe Hall in February 21, quick out the gates. That established that a specified list wording, which doesn't name COVID, unsurprisingly perhaps doesn't respond to COVID. Earlier this year, we had Corbyn and King against AXA. That was a denial of access wording, where I think the interesting focal point was the decision around aggregation. That's something that I will come back to shortly. Here, Corbyn and King successfully argued that separate limits of indemnity applied to each of the policyholders' premises, largely because of the wording of that particular policy. Looking to the future, you'll see there are still a number of prominent claims working their way through the courts. They're taking a long time, so you're looking at 23 and perhaps even beyond. So let's go to the current case, which raises a few key points, largely quantum focused around the what's known as the Marsh resilience wording. The first issue relates to the types of events which are covered and which trigger policy. And I'm going to pass over to Shaira for that. I'll then deal with aggregation and causation. And Shaira will come back to some specific quantum points. So over to Shaira for the covered events.
Thank you, Ben. So the first sort of key issue in all 3 cases related to the trigger. Essentially, what was the covered event that prompted the relevant insurance clauses of the policies in each case to respond, therefore activating the policyholder's right to an indemnity? In Stonegate argued that the trigger was the occurrence of an insured peril as defined in the policy. Insurers Amlin, however, argued the relevant clause was triggered only when a loss was suffered as a result of a covered event. The court did not actually answer which position was more appropriate. They simply identified what the covered events were for each insurance clause and applied that same approach across all 3 cases. As in the FCA test case, there were 3 insuring clauses. 1, notifiable diseases. 2, prevention of access, and 3, enforced closure. Turning to 1, the notifiable diseases clause first. In the Stonegate decision, and just to initially flag before turning to what was actually decided by the court, Stonegate did try to argue that there were 3 triggers, namely the 3 speeches given by the Prime Minister and First Minister of Scotland and Wales. However, they weren't able to advance any kind of significant argument at trial in support of this. It was determined by the court that the trigger was as many covered events or triggers as there were cases of COVID discovered at 1, an insured location, or 2, occurred within the vicinity of 1 or more insured locations. This position was adopted and referred to in the other judgments, which I'm just going to briefly touch on now. For example, in the various eateries judgment, Allianz's case against various eateries was that there was a single covered event, being the whole pandemic. This was rejected on the basis that a notifiable disease occurs when illness is sustained by an individual and that it will occur as often as there are cases of illness. Finally, on notifiable diseases, in the Greggs judgment, Zurich's case against Greggs was that a covered event would only occur when there had been interruption or interference with Greggs' business as a whole. This again was rejected on the basis that whether the insurance clause was triggered depended on each case of COVID-19 must be regarded as causing its own interruption or interference. Secondly, turning to the prevention of access clause, this very briefly was a question of construction. The express requirements for there to be cover under this clause were the actions or advices of a relevant agency in the vicinity of an insured location, which prevented the use or access of that insured location. The judge concluded that the number of triggers was actually the number of advices of such actions and not the number of advices multiplied by the number of premises. Finally, turning to, importantly, the enforced closure clause. In Stonegate, it was determined that the trigger for the enforced closure clause was the actual closure of all or part of the insured location under relevant compulsion or instruction. Therefore, the policy would be triggered in respect of each such closure, and the number of triggers is the number of insured locations so closed. Again, this was the position adopted in all 3 cases. So to conclude on this point of triggers or covered events, it is particularly important that the court found against Stonegate on its argument concerning triggers for covered events on a per location basis, but rather that they found that each case of COVID-19 that was either discovered at an insured location under the disease wording, or when any one of their locations was forced to close because of COVID-19 under the enforced closure wording, was essentially classed as a separate covered insured event. It's therefore theoretically possible for there to be multiple covered events at multiple locations. Insurers did not seek to argue the covered events point too much because they considered it was obsolete in light of aggregation arguments, specifically that it wouldn't matter how many losses there were since the losses would all be aggregated together. I'm going to pass over to Ben now, who'll actually touch further on this aggregation point.
Great, thanks. So aggregation was a massive battleground. In Stonegate itself, that was potentially worth upwards of £1 billion. So this is huge issue for them, and that's mainly because they've got 800 plus locations potentially affected. Now, you'll see the words of the relevant policy on the slide, which is essentially that if a BI claim is made which affects more than one location, if that arises from, is attributable, or is in connection with a single occurrence, then the limit of indemnity applies to all of the BI losses combined. Now, the court found that the unifying or causal link between the occurrences and the losses is the critical factor, which really must be tested by way of how a reasonable person in the shoes of the policyholder would have viewed the situation in March or April 2020, which is when the losses started to be sustained. Further, and really importantly for the outcome, is that the judge decided that the words on the slide "in connection with" denote a relatively loose causal link between occurrence and loss. Now, Stonegate argued that for the disease wordings, there were the same number of occurrences as the number of COVID cases in the vicinity of each of the premises. For prevention of access and enforced closure, each time there was a government announcement affecting any of the premises would amount to an occurrence. Now, on Stonegate's case, that would represent 19 separate occurrences, and I'll come on to why. Greg's, whose policy period extended through to the end of 2020 and therefore had the potential to be more significantly affected by COVID over that period of time, argued that there was 120 separate occurrences. As Shaira's mentioned, insurers argued that there was a single occurrence to which all losses should aggregate. How does this look like in practice? So across the three judgments, the judge went through this in significant detail. So I've really tried to break it down in a bit more basic terms to see the highlights. But from the prevention of access side of things, a decision or announcement made by the government could amount to an occurrence. So 16th of March 2020, the announcement for people to avoid social venues, the instruction for restaurants to close on the 20th of March 2020, they were both classed as occurrences. But the judge said that any losses caused by the 20th March announcement would probably overlap with those caused by the social venues announcements 4 days earlier and therefore aggregate together. Now, as you'll see from the first pink line here, announcements later in the year didn't affect Stonegate because its policy ended at the end of April 2020. For various eateries and Greggs, they had the potential to have more occurrences hitting their policy. So, for example, restrictions on restaurant opening on the 24th September 2020 was the only other announcement which the judge found would affect various eateries because their period of insurance ended on the 28th September. Greggs was able to claim for a couple of later events, tier system being brought in on the 14th of October, and then the second national lockdown on the 5th of November. They were classed as separate occurrences. One point to note that if an existing measure was simply renewed or maybe modified, the judge considered that would not amount to a separate occurrence. Now, you'll note of interest that none of these events included what was probably the most significant event for all of us on a day-to-day level, which was the announcement of the first national lockdown, the 23rd of March. Neither the policyholders nor the insurers advanced a case on that, and it's probably because it was so intertwined with the 16th March and the 20th of March events. But the judge thought it could be a further occurrence in its own right. But since pubs and restaurants were already locked down by that point, it was unlikely to be relevant for these particular policyholders. Now, this limitation to the number of occurrences, which could be linked together, represented a very significant win for insurers because it curtailed the potential cover available. Now, moving on to causation, policyholders and insurers both agreed that if losses were proximately caused by events occurring during the period of insurance, then they are in principle recoverable. The reason why this is a particularly sensitive area, particularly for Stonegate, is because, as I said earlier, its policy period only extended to the 30th of April 2020, but it had a 36-month indemnity period for some of these clauses. And so it needed losses occurring after the end of the policy period to be classed as being caused by events which occurred during the policy. So looking at the types of wordings again, prevention of access, enforced closure, that was fairly uncontroversial, I think. Cover would apply for any loss resulting from the prevention or the inability or the closure of the premises. But the extent of that cover is restricted by the length of the interference, and that was relatively straightforward to determine. The real battleground is the disease wording. And Stonegate argued that all of the BI losses it suffered or it sustained through to the end of its 36-month indemnity period were proximately caused by the occurrence of disease within the vicinity of its premises during that policy period. Now, the judge rejected that argument, and it found that the government's orders to close premises were primarily driven by current and projected cases of COVID rather than previous cases. Now, past cases may have had some influence on government response, and the reason for that was the time lag in obtaining up-to-date data, but new government actions outside of the policy period were caused by COVID cases occurring at the time those actions were taken, and not because of occurrences which had occurred some time earlier. A good way to look at this is by my very impressive drawing you'll see here, which is the various eateries policy. In that case, the announcement of the introduction of the tier system on the 14th of October was just over 2 weeks after the policy period expired. The court decided that that announcement was made because of the cases occurring around the time of that announcement. So the pink circles on the right-hand side, they were outside the period of insurance. It was not made because of the case which was occurring several weeks earlier, which were during the policy period, i.e. the grey circles on the diagram. So from a policy perspective, at least, policyholders are unable to claim that COVID-19 had a long-term impact. The losses recoverable under the policy are restricted to those flowing from at the time and not for months and years later. So I will pass over to Shaira to look at a couple of issues on loss. Shaira.
Thanks, Ben. So another issue that all three of the cases considered related to claims for additional increased cost of working and the application of sublimits. There were two main points of policy construction in dispute, which are actually on the slides, so I won't read them out again. But on point one, the court actually found in favour of the insured, Stonegate, in that the sublimit for additional increased cost of working applied for each and every single business interruption loss, essentially per each occurrence. Importantly, on point two, the court agreed with insurers that additional increased cost of working and increased cost of working were mutually exclusive. So additional increased cost of working cover was only available for or limited to costs or expenditure which were uneconomic in the sense that they had an effect on maintaining turnover. This is quite a significant distinction and means that where costs were incurred which were economic, this would fall within the scope of the single business interruption loss limit and not the £15 million sublimit for additional increased cost of working. Finally, turning to the final but a very significant issue considered in all three cases. This related to government support, specifically whether the claimants should give credit for 1, furlough payments received, and 2, savings or relief made on business rates. This, as you will know, was a question left unanswered by the FCA test case. Turning to furlough payments first, the court found that payments received by an insured, such as Stonegate or Greggs, under the furlough scheme was to be taken into account in loss adjusting calculations, so in calculating the sums recoverable or the indemnity under a policy. By taking into account, I mean that both the decisions confirmed that furlough payments were to be deducted from loss calculations. This was on the basis that they were either savings within the meaning of the policy itself, or potentially on the basis that there would otherwise be a form of double recovery. Therefore, payments received under the furlough scheme were taken into account for insurers' benefit when calculating an indemnity. It's also noteworthy that the insured's arguments that these furlough payments were simply a reimbursement of employment costs was rejected. The court considered that the basic rules of a contract of indemnity applied and concluded that where a third party has made a payment which eliminated or reduced the loss to an insured, insurers were entitled to the benefit of that payment, either in reducing any payment they might have to make under a policy or claiming an amount already paid from the insured. As an exception to this rule, insurers would not be entitled to the benefit of a third-party payment if it could be established that the third party intended only to benefit the insured to the exclusion of insurers. However, here there was no express statement from the government which indicated that payment was made only in respect of uninsured losses. Next, turning to business rates relief, a similar decision was reached in relation to this, although it depended to an extent on the nature of the accounting treatment of such relief. Payments made under business rates relief would not be accounted for to insurers' benefits if the business, such as Stonegate, could show that normally business rates would have been paid out of the turnover. If business rates would have been paid out of turnover, then business rates relief would fall within the savings clause and should be taken into account when calculating an indemnity under a policy. Therefore, unlike the court's finding in relation to furlough payments, business rates relief is a little bit more fact-specific per policyholder and policy. In summary, this final issue is of particular interest to insurers because any government support, so whether furlough payments and or business rate savings, will have a significant impact on the loss adjusting process, especially in circumstances where the insured premises has closed entirely and the policyholder has saved close to the full wage bill throughout the indemnity period. Whilst this finding has reduced the amount policyholders will recover from insurers, it does make commercial practical sense. These are indemnity policies and policyholders have already received support from the government with no obligation to repay, which has extinguished any loss sustained. A payment by insurers would amount to a double recovery. Further, should Stonegate or indeed the others proceed to appeal any aspects of the decision in respect of government assistance is less prone to judicial scrutiny, so therefore providing certainty and positive news for insurers. I think that's all I have to say. Ben has a little more to address specifically on the impact of these decisions on brokers before we finish this session. So over to you, Ben. Ben, I think you might be on mute.
So just to bring this to a conclusion, we've described it as a win, but also a loss for the three policyholders because the policies were found to respond, just not to the extent they were claiming. And I think the question for us all is, what are insurers going to do about this, and what's the implications for you as brokers? I think it's up in the air. I've looked at the websites of the insurers involved, and there's not a great deal of information there. I don't mean that by way of criticism, just simply the key issue is that the insurers have indicated, so Stonegate in particular, have indicated they are going to appeal this, and I understand permission has been given, but information about what happens next and the timings for that remains unclear. I think what we can say is that the FCA maintains a strong influence over this area. It is keeping an eye on what insurers are doing. It reported in October, so before these judgments were handed down, that £1.5 billion has been paid out to insurers to over 36,000 small businesses, which in its words were as a direct result of the test case. Now, the Supreme Court judgment in the test case does remain, because at Supreme Court level, it remains the key authority, but it didn't deal with everything. And I think it was probably hoped that these judgments would give maybe a bit more direction and assistance around quantum. And also, I suppose, what the data that the FCA provides doesn't show is how insurers are dealing with these challenging aggregation and causation issues. These three judgments, along with the Corbyn and King and AXA decision earlier in the year, do give some guidance, but these three in particular are quite a challenging read. There's probably about 200 pages worth of judgment in there. I don't necessarily think they provide the clarity which policyholders and their brokers would have liked. And as I say, the existence of appeal means that uncertainty on those issues remains. So we are going to have to wait for further judgments. And going by the way that the slide I showed you earlier about the timescale for these things happening, I doubt that's going to be particularly quick. We actually haven't had any questions during this, so perhaps we've answered all possible questions. So really, it just leaves me to sign off for today, and thank you for coming along. We're currently finalising our calendar for the box in 2023, so watch this space for further events next year. As ever, please do feel free to feed in the feedback forms which will follow. And do take the chance to propose subjects you'd like to talk to us. We're always looking for new material. So really just to wish you all the best for the festive season, and we'll see you at the box again next year. Thank you.
Thank you.